We'll now call 127-197 in the matter of Mark A. Sampson.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Madam Chief Justice, I'd like to request 2 minutes for rebuttal. Thank you. This is an original action in attorney discipline involving the respondent Mark A. Samsel. Mr. Samsel was admitted to the Kansas bar in 2010. On October 31st of 2023, the ODA filed a formal disciplinary complaint concerning 2 matters, DA 13-711 and DA 13-748. On November 9th, Mr. Samsel filed a timely answer, admitting to most of the allegations contained in the formal complaint. Thereafter, the parties decided to forego a disciplinary hearing and instead enter into a summary submission agreement on December 7th of 2023, pursuant to Supreme Court Rule 223. Parties have stipulated that Mr. Samsel's actions violated KRPC 8.4B, committing a criminal act that reflects adversely on a lawyer's fitness, 8.4G, engaging in other conduct that adversely reflects on a lawyer's fitness to practice law, and 8.4E, stating or implying an ability to influence improperly a government agency or official. Because the parties have entered into a summary submission agreement.
Can I ask about those violations real quick? I might get them out of order, but B, E, and G were under 8.4. One covers criminal act, which is the conduct that was pled to in this case. One covers influencing government agency, which is the letter to the Department of Education attorney. And then I can't remember, is it G or E? I get them confused. G, that's any other conduct that adversely reflects on fitness. I'm just wondering, in interpreting that rule, the any other conduct, does that, it seems to me that we could interpret that as any conduct that's not actually covered in B and E. So if it is covered in B and E, G arguably would not apply. Do you know what I mean? Because of that other conduct language, or am I how would you respond to that interpretation of the rule?
My understanding from talking to Deputy Disciplinary Administrator both, and then also looking at Mr. Samsel's answer, that the 8.4B and G violations related to the first complaint, DA 13-711, and then obviously the E violation, improperly influence, was the letter, the second complaint. The theory was how we were proceeding was the B was related to the convictions, and then G was related to the other conduct in the classroom that may not have arose to a level of criminal conduct, but still reflected adversely on his fitness to practice law.
Okay, so you're not necessarily arguing that's not an improper way to interpret the rule, but that the evidence actually fits that there is other conduct.
Correct.
Okay, gotcha. Thank you.
I was going to go into just because the parties we've entered into the agreement, the primary issue before the court is whether the court agrees with the recommended sanction of a stayed 1-year suspension and then placing Mr. Samsel on probation for 1 year. In order to give some context to the rule violations and the recommended sanction, I would like to give a brief summary of the facts. It's important to note that when respondent engaged in the conduct underlying both of these complaints, he was serving in the Kansas House as a state representative for the 5th House District. In the first complaint, DA 13-711, involved an incident that occurred on April 28th of 2021. On that date, Mr. Samsel was working as a substitute teacher at Wellsville High School in an art class. And while suffering from what his psychiatrist later described as a manic episode with psychotic symptoms related to a then undiagnosed bipolar disorder, Mr. Samsel caused a scene in the classroom when he told students that, quote, that he had the floor and that the class was going to, quote, be the most uncomfortable class of their life. Mr. Samsel proceeded to tell the class that God was speaking through him and then spoke about the God, devil, suicide, mental health with the art class. T, who was a student in Mr. Samsel's class. Mr. Samsel believed that T was being disruptive. And at one point, Mr. Samsel grabbed T from behind and picked him up. Later, he shoved T into a wall. And at a later point, Mr. Samsel told T that he was going to kick him, quote, in the balls. And then shortly thereafter, kicked T in the groin area. After kicking TE, he told another student in the classroom, quote, check TE's nuts for him. Mr. Samsel grabbed another student, JG, by the shoulders and asked her whether she had mental health problems. Mr. Samsel's actions caused JG to believe that Mr. Samsel was going to hurt her. The situation Mr. Samsel created made several students uncomfortable, causing them to leave the classroom while this was going on. Mr. Samsel was arrested by law enforcement the next day. He was ultimately charged with 3 counts of misdemeanor battery. On September 13th of 2021, Mr. Samsel pled guilty to 3 amended charges of disorderly conduct, all Class C non-person misdemeanors. He received 12 months of probation with an underlying 90-day jail sentence, and he successfully completed his criminal probation. Parties agree that Mr. Samsel's conduct relating to the classroom incident violated 8.4B and 8.4G. The second complaint, DA 13748, concerns Mr. Samsel's actions in responding to the Kansas State Department of Education's attempt to have his emergency substitute teaching license revoked due to those actions in the classroom. On June 15th of 2021, Dr. Michelle Miller, director of the Kansas State Department of Education's teacher licensure and accreditation team, filed a complaint to initiate proceedings with the State Board of Education to revoke Mr. Samsel's substitute teaching license. Attorney Scott Gordon represented the Department of Education in the matter. Mr. Samsel represented himself. On July 30th of 2021, Mr. Samsel emailed a letter to Mr. Gordon and 2 constituents of the Department of Education, Dr. Randy Watson, the Commissioner of Education, and Dr. Miller, the aforementioned Director of Teacher Licensure and the accreditation team. The letter Mr. Samsel sent to the 3 individuals was significant because despite the licensure matter having nothing to do with Mr. Samsel's service as a state legislator, the letter was written on his legislative letterhead. Throughout the letter, Mr. Samsel referred to his work as a legislator and implied that based on his status as a legislator, the Department of Education should consider working with him rather than taking an adversarial position against him regarding his substitute teaching license. Ultimately, the respondent stipulated that this conduct violated 8.4E, implying an ability to influence properly a government agency or official. The ODA believes that the recommended sanction of 12 months of probation is appropriate, given that Mr. Samsel's conduct, while serious, was caused by him suffering from bipolar disorder, and that the probation plan is designed to ensure that Mr. Samsel continues to receive treatment for his mental health that, according to his treating psychiatrist, since February 16th of 2022 has been successful in keeping the symptoms of his bipolar disorder in remission.
Counsel, can I stop you and ask you a couple questions about what you were just describing? And I think you said a direct quote from the summary submission, which I think is little I2 in the mitigating factors on page 15. It starts at the bottom of page 15. The mental disability caused the misconduct. And then there are a number of paragraphs that recite the substance of the doctor's testimony, or maybe it wasn't testimony, but statement.
A letter, and it's Exhibit A.
Okay. My question really goes to all of this, but it strikes me that the bulk of this, if not the entirety of it, is describing the causal connection between the mental health of the respondent and the April 28 incident. But I'm having a hard time seeing the connection between the mental health state of the respondent and the second complaint. Can you help me or maybe walk through that? Because even just the underlying facts don't strike me as conduct that is typically associated with a bipolar mental state.
In Exhibit A, which is Dr. Garrett Lambert, who's the treating physician, he explains that the manic phase that Mr. Sam was going through was still taking place as of July 30th of 2021 when the letter was written. And also included in his letter was noting that as part of this manic episode that Mr. Samsel was experiencing, I think, and I might be incorrectly paraphrasing, but the doctor said that the manic symptoms also Samsel as a result displayed delusions of grandeur. And so I would argue that those symptoms may have resulted in the self-importance that was shown in the letter that was written to the.
But
Department of Education.
self-importance is not that's not really what the violation alleges that he was bringing undue and inappropriate pressure to bear on KDH, the Department of Education. Is that right?
Yes.
That actually strikes me as a very rational, calculated effort to use one's position of influence to reduce possible consequences, not as something that's influenced by delusions. It doesn't strike me as delusional at all. Yeah, I'm just trying to connect those dots. That's
Maybe the decision to write such a letter was that because of his bipolarism, he was more amenable to making that decision. A legislative letterhead and to refer numerous times to his actions as a legislature to benefit. That would be my best explanation for that.
Counsel, do you have any more, do we have a more current medical assessment than Exhibit A dated October 2023? And I'm just,
We do not from Dr. Lambert.
anybody, I'm just trying to get the medical
Right.
side of this thing. Or at least, I guess maybe what I'm trying to do is get the compliance with the medical regimen.
Right. Part of his KLAP monitoring agreement includes routinely seeing Dr. Lambert. I just spoke to Cal Williams, who's serving as his KLAP monitor. Cal Williams has assured me that he is in full compliance with his plan. That was just as of last week, but I have nothing in writing.
And that monitoring agreement and the probation plan, by its terms at least, looks to expire of like April of this year. It has expired. And I think that the agreement says that there's an agreement to continue the monitoring plan throughout probation. But I assume the parties also intend to extend the probation plan beyond that term as well, but I didn't see that language explicitly, but I assume that's the agreement. Of the
Yes, I
parties.
mean, the parties would, I would imagine Mr. Sampson would be in agreement to continuing the terms of probation for however long this court ultimately orders him.
Your deal, I got a little confused going, your deal that you're monitoring.
1 year.
Is that paragraph 36 of the summary submission agreement? Or maybe it's 37. Is there anything in the terms of the summary submission agreement that aren't already incorporated in the probation plan or the monitoring agreement? Or are those just sort of a summary of those terms in those two documents?
I believe all the terms from the submitted probation plan are included in there. I'm not for sure if I don't believe all the terms of the monitoring agreement. Actually, maybe C. But I believe that the intent of Deputy Disciplinary Administrator both was to include all the conditions by reference, at least from the probation plan and the monitoring.
But there's no new terms, so to speak, in the summary submission agreement itself. It's,
As far as I know,
Yeah.
they're not.
Can you remind me what happened in the underlying criminal case?
He pled guilty to 3 counts of disorderly conduct in September of 2021.
Battery.
No battery.
And disorderly conduct, and so what was the sentence?
It was 12 months of probation with an underlying 90-day. In conclusion, the ODA would ask the court to accept the party's summary submission agreement, impose the party's recommended sanction of a stayed 1-year suspension, and place Mr. Samsel on probation for 1 year, subject to the conditions laid out in the summary submission agreement. Questions for me?
Good afternoon, Your Honors. May it please the court. Mark Samsel, the respondent. First of all, I want to apologize. It is my conduct that got all of us here today and used the court's time and resources of everybody else here. As you've seen a lot of in the documents, it was 99% or more a manic episode from a bipolar disorder I didn't know I had. And if you would have asked me to tell you what bipolar disorder was before this stuff started, I couldn't have told you anything. It started actually a few years before any of this that is before you today. It started with cycles of depression that went on for weeks and months at a time. I started seeking treatment at that time. Wasn't later diagnosed until way on down the line that it was bipolar disorder instead of depression. So we treated depression, thought we beat it, and this cycle continued. And so to address one of the justice's questions, a very good question about the length of time between the first incident and the second incident. That's, as I learned, mania can go on for weeks or months at a time, especially when your brain is in that elevated, agitated state. And Dr. Lambert mentions this in his letter that's in the record in more detail, but just very briefly, I was attending those criminal proceedings. And then of course, I was unfortunately also a state representative at the time. So it was highly publicized and agitating more than perhaps just a regular proceeding had you bipolar disorder. So my brain was continually staying in that agitated manic mode. By definition, when you're in manic mode, that means you're not able to identify you're up in that state of mind. So that was the length of time, Your Honor. The first time was in the classroom, and then yes, weeks and then even months later, as I wrote that letter, I thought God was calling me to still make this an event to bring attention to mental health. I obviously was wrong in hindsight, but at the time I thought I was correct. That's why I made the mistake of putting it on state letterhead instead of a personal letter, something of that nature. And I regret that I did it, and I apologize that I did it. I don't know that my intent was ever to try to influence them. I honestly was just trying to communicate with those two individuals, and the attorney, I don't know, for whatever reason, didn't really want me talking to them, even though I thought I had the right to, since I was the defendant. But if the court has any questions about that, I'm happy to answer those. I also want to thank Mr. Vogelsberg for stepping in today. Amanda Voth did an exceptional job working with me. I appreciate her professionalism. I appreciate KLAP and my monitor, everybody who was involved helping me through this process. It has not been an easy process, but it's one that I'm very thankful. I had a great career leading up to this incident. I worked with some wonderful attorneys that got to mentor from up at the law firm in Kansas City while this bipolar stuff was going on unknowingly and then after the fact. So I got to learn from some of the best. And I'm very appreciative of everyone in that who's also supporting. But I guess for today's purposes, though, we're asking you to approve the SSA. To address the justice's question about the criminal proceedings, I did apply for a diversion at the time on the basis that it was a manic episode. I think they made the right decision in denying that because I was still manic while I was making that application to the court. So we went through the process then. I worked very closely with the district attorney, as I've tried to with everyone. I guess it would be helpful for the court to know, I think finally in about September of 2021, when the criminal proceedings, we finally reached that agreement, my brain finally was able to come down from that manic episode that it was in, because that's when the agitation, the news proceedings, all of those things had finally slowed down and stopped. And my brain not only returned to more of a normal level, if you will, but then started dipping down into the depressive state over the course of days, weeks, and months. And that's finally, thank goodness, I regained my wits enough to listen to Dr. Lambert as he's saying, I think you've got bipolar disorder. We need to try some different treatment for that. We tried a couple medicines that did not work. Of course, with mental health, it takes weeks, 2 months, 3 months in order for those medicines to start taking effect. So for 2 or 3 months, the first one did not work. Same with the second one for another 2 or 3 months. So it wasn't until, as council mentioned, February 22, we went with old school lithium. That's the gold standard, which I did not know at the time, but thank goodness it has worked ever since then. So I have not had a single symptom, either manic, depressive, ever since that medicine finally started working in about February 2022, right around that time frame. So a little over 2 years now.
Let me ask you, looking forward, assuming we were to do the probation period, all that, what would be the nature of your law practice?
Good question, Your Honor. Not much different than what I've been doing recently. I did, to be honest with you, for a time as all that was going on, I pretty much shut down my law practice completely because mentally I wasn't in a good spot to be doing it. And of course, and that's what was leading to some of these things. So I actually took, it was a very humbling experience, a warehouse job that I did back in college just to keep things going and very minimal law practice. As once I got on the treatment and the lithium was working, I went back to more of like a part-time 2 or 3 local clients who I enjoy working with, construction clients, business contracts, collections, disputes, those types of things for them. And I've kind of been doing that ever since then. And then just more recently, it's been a little bit more of that. I tried to work with my doctor and make sure that our track moving forward was something that was consistent with me still having the bipolar symptoms fully in remission, which it has been, but that would be my intent moving forward, is still about 20 hours per week of doing business contracts, things of that nature, construction.
Solo practice.
Yes, sir.
And does that, do the agreements have, you have an attorney supervisor at all? Or is it all just geared towards ongoing mental health treatments and?
Good question, Your Honor. We actually considered that, but we decided, looking at the history of it, and if the court wants us to do that, we could certainly reconsider it. But we decided with the KLAP monitor and just making sure my health stayed with my treatment, if that was in order, we didn't necessarily see any other, it was never per se a practice issue. It was my behavior that was causing the issue, which was mostly unrelated to the practice, if that makes sense. Unfortunately, I don't mean to excuse that behavior because it was terrible, but. I think that's all I had, Your Honors. Again, I do deeply apologize. It was embarrassing, not just for me, but for everybody involved, the state of Kansas, the bar, and everybody else. I have done my absolute best as I've moved through, especially once I got back to where my mental health was back in my normal state. To be very transparent with it, very honest with it, as difficult as it might be, but try to help others with mental health in the profession. They still don't know what causes it, but I would bet quite a bit that I think it was cumulative stress and burnout from the law practice itself. Of course, then you throw on the state representative stuff and some other things, but certainly have learned a lot through this process. I'm happy to do whatever the court, KLAP, the disciplinary administrator's office would like me to do moving forward. But it is, I mean, as much as I wish this whole thing could have been avoided, I'm trying to do my best to use it for as much public good as possible. As you saw in the record, I did actually go to some length of writing that article for the Kansas City Star, of kind of giving my not only public apology, but this is kind of the transparent things of, as crazy as it sounds and it was, of the classroom and all the other stuff, this is how the brain got in that condition where you didn't even realize those were the things that were going on. So in closing then, unless the court has any questions, we would ask the court to approve the summary submission agreement, and I thank the court for its time.
How are you doing now?
Your Honor, I've been doing great ever since the lithium started working 2 years ago. And honestly, and I actually honestly enjoy the practice of law again, which for even 3 or 4 years prior to the incident leading to this, the depressive cycles and the other things that had started, it was not fun. And I was seeking help with my mentors and others within the law firm and professionals, and we just didn't know what it was. So that whole cycle, in hindsight, if there was a way that I could have learned more about mental health earlier, I wish the whole bar would know that type of stuff. But ever since, Dr. Lambert has been amazing. He was actually a former law practitioner, and he was smarter than me and got out of the practice of law, then went back to medical school. But following his recommendation for lithium, which he's told me, going by the book only works about 10% of the time in mental health, but that is what has done the trick for me. If I ever get any inkling, or as my parents or family or friends, as I told them, if you ever get any inkling that I'm off base, please, 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 not only tell me, but my doctor or whoever you need to, because this whole experience is not one anyone would ever want to go through. Thank you, Your Honors.
Unless the court has any questions for me, I would wait.
So thank you to both of you for your arguments. The court will take this matter under advisement.